In the early 1830s, the Supreme Court in the case of Barron versus Baltimore ruled that the Bill of Rights did not apply to state governments. In the wake of the Civil War, though, the Congress that convened was determined to formalize the progress that had been made in the defeat of the slaveholding South. And a big part of that project was the extension of constitutional protections for civil rights to state governments. The ringing words they wrote, though, in the Privileges and Immunities Clause of the 14th Amendment, ended up diminished and constrained by a Supreme Court that was actually in the process of trying to legitimize the legislation of Northern-imposed Reconstruction governments. For a happy ending, we'll have to wait for next video. But for now, let's talk about the 14th Amendment, some very angry Cajun butchers, and a physician turned Supreme Court justice named Samuel F. Miller. When we think back to the Civil War, we often think that the moral outrage was wholly and solely pertaining to the horrific treatment of enslaved black people. The hard truth, though, is that the majority of white Northerners did not at this point embrace our modern understanding of complete racial equality. That would evolve, with legal racial equality becoming the dominant platform in the post-Civil War Congress. At least at the beginning of the war, though, that wasn't the consensus. What the North could agree on, though, was that it was imperative, even if it took fighting a civil war, that they destroy a barbaric system of bondage that saddled entire societies with a tendency towards cruelty, vicious class divisions, and the aggressive suppression of any dissent. Because in the antebellum South, a system of such flagrant evil and abhorrence could only be maintained by comprehensive social control. This only worsened as time went on, and the South felt more and more threatened by a North that was not just politically and economically more powerful, but continually pointed out the South's reliance on the backwards barbarism of slavery. To show how toxic the issue of slavery became, let's take a look at a few different pieces of legislation. The first being the Northwest Ordinance of 1787, passed by the precursor to the U.S. Congress, the Confederation Congress. The act provided for the organization of the territory to the northwest of the existing states, and shortly before passage, Article 6 was added, which stated, "There shall be neither slavery nor involuntary servitude in the said territory, otherwise than in the punishment of crimes whereof the party shall have been duly convicted." Interestingly, the act was promptly passed, unanimously, by all 8 states present, 4 of which, Virginia, the Carolinas, and Georgia, would go on to join the Confederacy. This is shocking, particularly in view of the fact that the status of slavery in new states would prove to be the most intractable issue of mid-1800s American politics, resulting in a series of crises that culminated in the Civil War itself. Of course, this doesn't mean that elite Southern society in the Revolutionary period was full of abolitionists. But clearly, the idea that slavery's years were numbered, and that it was neither desirable nor sustainable for the country as a whole, was far from taboo. As time went on, the institution of slavery came more and more under attack, and slave states fought back. In 1829, Georgia passed a law making it illegal to teach slaves to read or write under penalty of fine and imprisonment. In the 5 years that followed, Alabama, Louisiana, and North Carolina followed suit. It was in this environment that the U.S. Supreme Court handed down the Barron versus Baltimore decision, allowing the federal judiciary to steer clear of what were increasingly egregious encroachments on civil rights for even white citizens. If you'd like more information on that ruling, check out the previous video in this series, linked here. As early as 1803, we can find a Tennessee law which forbade, under penalty, uttering, in the presence of slaves, words of inflammatory character respecting emancipation or inciting rebellion. These sorts of laws were fairly commonplace, and by 1837, Missouri had passed an act to prohibit the publication, circulation, and promulgation of the abolition doctrines. These sorts of laws weren't just symbolic. Under the Missouri statute, a first offense carried 2 years in prison, a second 20, and the third life in prison. Again, just for free speech regarding the institution of slavery. It even got to the point that on March 6, 1857, the Louisiana legislature declared that from and after the passage of this act, no slave shall be emancipated in this state. Slave owners themselves no longer had the right to free their human property. As Congressman Tobias Plants of Ohio put it in 1866, the slave system would not be secure if men in the slave states were permitted to discuss the matter in any form, and hence freedom of speech in the press must be suppressed as the highest of crimes, and no man could utter the simplest truths but at the risk of his life. For more than a quarter of a century, the world knew no despotism so absolute and reckless as that which ruled the South. On April 12, 1861, South Carolina militia forces attacked the U.S. Army base at Fort Sumter. After 4 grueling years of war, the South surrendered, and the difficult task of reassembling the Union began. Despite the obstructionist efforts of then-President Andrew Johnson, congressional Republicans undertook a sustained effort to pass legislation that would permanently abolish slavery and its attending injustices. On December 6, 1865, slavery was officially abolished under the 13th Amendment. Soon after, though, Southern legislatures began passing black codes, which, while they didn't officially reestablish slavery, legalized social control over black people. Separate judicial systems were created for blacks and whites. Blacks were required to regularly report on their employment and could even enter as servants for pseudo-masters. On March 2, 1867, Congress had enough of the Southern maneuvers and passed an act to provide for the more efficient government of the rebel states. This act reestablished military control, ordering that said rebel states shall be divided into military districts and made subject to military authority, and that each state may not be readmitted to the Union until they rewrote their state constitutions, and when said state shall have adopted the amendment to the Constitution of the United States, proposed by the 39th Congress and known as Article 14. The 14th Amendment was thus designed to guarantee that race-based legal control and the oppressive legal structures of the antebellum South would not be resurrected. Sections 2 through 4 dealt with such things as discouraging voting restrictions, refusing responsibility for Southern war debt, and making sure that Confederate officers wouldn't be able to hold U.S. office. But Section 1 rings the loudest, stating that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. The first half consists of the Citizenship Clause and the Privileges or Immunities Clause, whereas the second half consists of the Due Process Clause and the Equal Protection Clause. In this video, we'll only be dealing with the first half. The exact meaning of the first half of Section 1 remains the subject of much debate, but let's start with the first sentence, which states that all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. While it seems fairly basic, this explicitly rebutted what is known as the compact theory of the Union. Southern states had long held that the Constitution was a compact of the states, and that national citizenship arose solely as a secondary effect of an individual's state citizenship. For example, on January 22, 1833, South Carolina Senator John C. Calhoun submitted a resolution to the Senate, which stated that the assertion that the people of these United States, taken collectively as individuals, are now, or ever have been, united on the principle of the social compact, and as such, are now formed into one nation or people, or that they have ever been so united in any one stage of their political existence, are not only without foundation in truth, but are contrary to the most certain and plain historical facts, and the clearest deductions of reason. This sounds shocking to us now, and was ardently rebuked by others at the time. Most notably, Massachusetts Senator Daniel Webster stated that the gentleman's resolutions then affirm in effect that these 24 United States are held together only by a subsisting treaty, resting for its fulfillment and continuance on no inherent power of its own, but on the plighted faith of each state. In the Constitution, it is the people who speak, and not the states. The people ordain the Constitution, and therein address themselves to the states, and to the legislatures of the states. So by stating that all people born or naturalized in the United States are citizens of the United States and of the state in which they reside, The 14th Amendment both enshrined birthright citizenship into the United States and federal citizenship as a distinct legal entity. Next, the amendment states that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. To better understand the exact meaning of this clause and the confusion that still surrounds it, let's take a look at one of the original clauses from the 1789 Constitution, which bears striking similarity. Article 4, Section 2 of the Constitution states that the citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. Well, what are the privileges and immunities of citizens in the several states? You might be tempted to deduce that the several states means the United States. So those privileges and immunities are those common denominator rights that are accessible to any U.S. citizen, or the Bill of Rights. But that's actually not how this clause has been received. After all, as we learned in our last video, the Supreme Court ruled that the Bill of Rights was not applicable to state governments. Rather, this clause was conceived and received as a protection against state discrimination against citizens of other states, so that any person who was traveling to another state would be entitled to equal treatment under the law as if they were a citizen of that state. As Justice Joseph Story wrote in his Commentaries on the Constitution in 1833, the intention of this clause was to confer on all citizens, if one may so say, a general citizenship, and to communicate all the privileges and immunities which the citizens of the same state would be entitled to under the like circumstances. Under this interpretation, the Privileges and Immunities Clause of Article 4 of the Constitution did provide for a conception of general citizenship, but that concept only extended to the equitable application of state laws, and it did not confer a distinct set of basic common rights to all citizens. Even to this day, that understanding remains the common scholarly accepted consensus regarding the meaning of the original Privileges and Immunities Clause. But it wasn't the understanding of the drafters of the 14th Amendment. Let's take a look at the words of the principal drafter of the Privileges and Immunities Clause of the 14th Amendment, Ohio Congressman John Bingham, in a debate on the Enforcement Clause of the 14th Amendment and referencing a speech by then-President Andrew Johnson. The President in the message tells this House and the country that the American system rests on the assertion of equal right of every man to life, liberty, and the pursuit of happiness. But sir, that statement rests upon higher authority than that of the President of the United States. It rests upon the authority of the whole people of the United States, speaking through their Constitution as it has come to us from the hands of the men who framed it. The words of that great instrument are, "The citizens of each state shall be entitled to all privileges and immunities of citizens in the several states. No person shall be deprived of life, liberty, or property without due process of law." Gentlemen, admit the force of the provisions in the Bill of Rights, that the citizens of the United States shall be entitled to all the privileges and immunities of citizens of the United States in the several states. But they say, we are opposed to its enforcement by act of Congress under amended Constitution as proposed. Bingham then made it explicitly clear that he believed that the Barron versus Baltimore decision was wrongly decided, stating that a gentleman on the other side interrupted me and wanted to know if I could cite a decision showing that the power of the federal government to enforce in the United States courts the Bill of Rights under the Articles of Amendment to the Constitution had been denied. Mr. Speaker, on the subject, I refer the House and the country to a decision of the Supreme Court to be found in 7 Peters 247 in the case of Barron versus the Mayor and City Council of Baltimore, involving the question of whether the provisions of the 5th article of the amendments to the Constitution are binding upon the state of Maryland. The principal drafter of the Privileges and Immunities Clause of the 14th Amendment stated explicitly that he believed that the Bill of Rights was meant to extend to apply to all state governments, and further, that the Barron versus Baltimore decision was the exact type of decision that would be overturned by the passage of the 14th Amendment. And soon thereafter, Section 1 of the 14th Amendment was passed, unchanged, as it had stood during that debate. So, end of story, right? The Privileges and Immunities Clause of the 14th Amendment extended the Bill of Rights to all U.S. citizens, and that's the state of the law. Well, that's not what happened. And this issue of the exact privileges and immunities contemplated in the 14th Amendment would not be settled until a series of fiercely litigated cases worked their way up from the Louisiana courts of New Orleans all the way to the Supreme Court. New Orleans in the 1800s was plagued by disease, far more so even than other cities of the era. Aggravated by a swampy climate that drew yellow fever spreading mosquitoes, the mortality rate in the mid-1800s in New Orleans was 8.1%, meaning that almost 1 in 10 people in New Orleans would die in a given year. That was more than 3 times the rate of the large northeastern cities like Philadelphia, Boston, and New York. Particularly repulsive were the city's slaughterhouses, which were scattered haphazardly throughout the city and left awful in the streets. As had been done in other major cities in both the United States and Europe, concerted efforts had been made to centralize all animal slaughtering activity into one or few central slaughterhouses, or abattoirs. In particular, in New Orleans, efforts were desperately needed to move all animal slaughtering activity downstream of the 4th District, where the intake pipes for the city's water supply were continually contaminated with animal waste. In the late 1860s, under a Louisiana Reconstruction Congress that was more than 1/3 African American, these efforts finally came to fruition with the New Orleans Slaughterhouse Act of 1869, which gave the Crescent City Livestock Landing and Slaughterhouse Company exclusive right to operate a slaughterhouse within the city limits for a period of 25 years. The act required that the company allow any butchers to slaughter animals on their premises at rates fixed by the legislation. This angered butchers who wanted to continue to slaughter animals in their own facilities. But the unbridled, vitriolic outrage against the act is only understandable in the context of fierce resentment against integrated Reconstruction governments. The company continually faced allegations of corruption and misdealings that were intimately tied to central governmental figures, including the Louisiana governor himself. It appears that these allegations were not entirely unsubstantiated, even if not out of character for New Orleans politics of the time. Regardless, the concept of a centralized slaughterhouse itself was sound, and the company that was contracted was capable of executing that function. After its passage, lawsuits crisscrossed the city, injunctions filed against the company, individual butchers, and a joint advocacy group called the Butchers' Benevolent Association. The butchers alleged that the company was an illegal monopoly, whereas the company and city argued that the slaughterhouse was a proper exercise of the city's interest in maintaining the safety and cleanliness of the city. Ultimately, the Louisiana State Supreme Court consolidated all of the cases into a single decision, in which they ruled on behalf of the Crescent City Centralized Slaughterhouse. The butchers appealed to the Supreme Court and were represented there, as they had been in state court, by former Supreme Court Justice John A. Campbell. Campbell had resigned from the Supreme Court to join the Confederacy, and his arguments showed a keenness to turn the Reconstruction Amendments on their head and use them as a battering ram to undercut the authority of the integrated Reconstruction governments. Campbell argued that the requirement that the butchers perform their profession through the Crescent City Company constituted involuntary servitude as prohibited by the 13th Amendment. He further argued that the act violated the 14th Amendment and the privileges and immunities of citizens of the United States because under his interpretation, those included the right to pursue one's own career uninhibited. If Campbell's interpretation was upheld, this would be an embarrassing blow to Reconstruction on the basis of its own highest aspirations. The city and company, for their part, argued that the legislation was a proper exercise of the city's municipal authority, but went further, arguing that the 14th Amendment contemplated nothing further than ensuring the rights of newly freed African Americans. Ultimately, on April 14, 1873, the court returned with a 5-4 narrow decision in favor of the city and the Crescent City Company. Under pressure from vigorous dissents, which stated that the 14th Amendment rendered the legislation unconstitutional, Justice Samuel Miller, who had actually once been a physician and was sensitive to issues of sanitation, stressed that the context of the passage of the 14th Amendment must be taken into account, that being ensuring the civil rights of newly freed blacks. Miller then elaborated on this point, asking rhetorically if it was intended to bring within the power of Congress the entire domain of civil rights heretofore belonging exclusively to the states. After discussing the far-reaching implications of an answer in the affirmative, Miller stated, without any citation, that we are convinced that no such results were intended by the Congress which proposed these amendments, nor by the states that ratified them. It is unclear if Miller understood or intended the consequences of his ruling, but what is clear is what came next. In ruling after ruling, the Supreme Court held that the 14th Amendment's Privileges or Immunities Clause did not change the fundamental rights of citizens as they stood before the Civil War, and so the Bill of Rights still did not apply to the states. And so it was that a ruling that was designed to affirm the legitimacy of Reconstruction government legislation undercut Reconstruction's very aims and paved the way for decades of state infringement and discrimination. We are not yet at the end of our story, though. The second half of Amendment 14, Section 1, the Due Process Clause, would go on to play the role that the Privileges or Immunities Clause had been precluded from fulfilling. For that, though, we'll have to wait a few more decades and for our next video. Thanks for watching this video, and if you enjoyed it, please give it a like and subscribe to this channel. It really helps. See you next time.